So, today I want to talk about child labor, lunch breaks, and the tactics of conservative politicians. For well over a year now, there have been numerous bills across the United States put forward in order to loosen the restrictions on child labor at the state level. This has included things like removing work permit laws, removing age verification checks, allowing younger children to work in dangerous occupations, including factories with heavy machinery, and the extension of allowed work hours during times of year in which school is in session. Much of this, of course, has been done in order to weaken the labor movement and to drive down the costs for businesses by hiring younger employees at lower wages, as well as to allow employers to continue to exploit vulnerable populations with little to no repercussions. This, of course, has been accompanied by bills and measures that have been designed to make it more difficult for families to survive by cutting things like unemployment, reducing workers' compensation, eliminating social safety nets like food stamps and Medicaid, and specifically targeting union activity like collective bargaining. Much of this has been initiated by a Florida based think tank called the Foundation for Government Accountability, who create model legislation to further their heinous causes. Now, I have covered all of this before, the links are down below. And while that is the case, I can also promise that in the future, while I am still making videos, I will be coming back to these topics again and again, likely to address this specific organization and others like it, especially as I now have a year plus worth of stuff to come back to and revisit. So, with that reminder out of the way, today I want to focus on one specific bill that has come out of Louisiana and has recently passed through their House of Representatives. At the time of recording this, the bill is now in the hands of the Louisiana State Senate and is very likely to see its final passage within the next day or so. From there, it will almost inevitably be signed into law without question by Republican Louisiana Governor Jeff Landry. Now, the bill in question is HB 156, which is intended to repeal a law that requires employers to provide at least one mandatory recreational or meal break for children who work more than 5 hours. Now, to clarify and repeat that, this is a bill that, if made law, would make it so that employers are no longer required to give children breaks during their workday. Now, I'm assuming that most people with sense that are watching this are immediately angry and are waiting for me to explain the rationality of why this is horrific, or to explain and exclaim how this bill sounds cartoonishly evil, because it does. However, I want to approach this a little differently today. The person who introduced this bill is a Republican by the name of Roger William Wilder III. He is the owner of 19 Smoothie King franchises across the South, and who hires a large number of teenagers in his stores. Instead of simply breaking down the issues with his proposed bill, I want you to see how this man justifies this bill and break down his tactics in order to better understand the manipulative language that is being utilized in the attempt to twist this contemptuous concept into something that appears reasonable when, as we all know, it is not. So, in order to do this, I will first begin to read you the law that is being repealed and then play some small clips from two different moments in which it was discussed in the Louisiana House of Representatives and respond to the points made by Representative Wilder in those clips. So, first, let's take a look at the law that is being repealed. So, we have here that the Louisiana state law states that recreational or meal periods, in this case, no minor shall be employed, permitted, or suffered to work for any 5 hour period without one interval of at least 30 minutes within such period for meals. If the period of work before the interval exceeds 5 hours by 10 minutes or less, the difference shall be considered de minimis. So, de minimis should be just seen as like the word trivial, right? Like that basically means that it's not important. There's leeway. There's a 10-minute leeway going on here. And shall not be considered a violation of this section. Such interval shall not be included as part of the working hours of the day. This interval shall be 30 minutes. If the length of the meal break is at least 20 minutes, the difference between the actual break time and the required 30-minute break time shall be considered de minimis, and shall not be considered a violation of this section. The break shall be documented using the employer's normal timekeeping system. If a minor fails to clock in or out for a work period or meal break, and a time edit is necessary, the time edit shall be documented and acknowledged in writing by the minor and the manager who perform the time edit. I think all of this is more or less reasonable. But now let's hear the purpose of this bill to repeal all of this in Representative Wilder's own words.
This bill is about maximizing employment and providing employers with the workforce that they need. Through this dialogue, I attempt to convey that this bill is a positive for both team members and employers, regardless of the name and the words that have been thrown around. We've heard both the governor and Ms. Susie Schoen from the Workforce Commission have both said repeatedly, removing barriers and removing burdensome regulation, and in this case, obsolete regulation, is what we need to be doing to help businesses move forward. Barriers such as additional paperwork, fines, loss of productivity, more incentives to simply not hire minors.
As you can already hear, the explicit goal of this bill is to provide employers with the workforce that they need, namely minors. Even before he gets into any justifications, he tells you exactly what its intended purpose is and who this bill is meant to serve. It is meant to make it so that it is easier to hire and thus exploit younger workers, and the way he hopes to do this is by removing a break requirement, as well as any accountability and paperwork requirements that his managerial staff seemingly can't handle.
Currently, the state, at the cost of clocking out, is playing babysitter for the team member. What do I mean by that? The only way for the state to verify that their babysitting service for the 16 and 17-year-olds is in effect is to force them to clock out. Then if they make a mistake, the law states that if a minor fails to clock in or out for a mandated work period and the time edit is necessary, now in 2024, since this is a 1976 law, the time edit shall be documented and acknowledged in writing by the minor and the manager. So now we got to go chase, if you're a manager, you got to go chase the team member down to get a signature on a piece of paper in 2024. So the obsolete nature is just absurd.
The reality is that this bill is self-serving and represents a conflict of interest from someone who employs teenagers at his businesses. The fact remains that these teenagers will be subject to lower wages, are less likely to know labor laws, and are far less likely to stand up for themselves compared to adults who work equivalent jobs. Despite those realities, Representative Wilder seems to have some opinions on minors and when they become adults.
I think our young adults, because when I hear the word minor, I think of an 8 or a 9-year-old. When I hear 16 and 17-year-old, I think of a young adult. I believe that our young adults can make decisions without a babysitter. I believe this age group is plenty capable of deciding if they would like to change jobs if they're in an environment that does not help them. And for the record, every business I've spoken to offers all team members a break.
And you mentioned the minor. You really believe a minor at 16 or 17 is a young adult?
I do. I do. We treat them as such in the state. The emancipation age is 16. You're allowed to marry at 16. You're allowed to drive at 16. Those are all adult actions.
With consent? With parental consent?
Well, absolutely, but you also have a parental consent when they have to sign a work permit for a 16 or 17-year-old to work. Seriously? I don't know the difference between 18 and 17 and 11 and a half months, but again.
First off, there is a big difference, legally speaking, between someone who has reached 18 years of age and someone who has not. People under the age of 18 require parental or guardian consent to work and do numerous other activities. Perhaps more important and to the point, though, is that labor unions and leftists have fought hard to create and maintain such minimum age laws, as it tends to protect children, reduce injury and personal risk, as well as allow children to live out their childhoods and focus more on themselves and their education. Meanwhile, the category of young adult usually refers to people between the ages of 18 and 22, or 18 and 25, depending on the circumstances. But it always starts at 18 years of age in the United States, because we've all collectively agreed on 18 as the age when one is an adult here in the United States. And I think it's more telling here that Representative Wilder has specifically focused on work requirements as the thing that needs to be changed, rather than things like, say, voting age or when a child is considered old enough to drive. Those are the factors that Representative Wilder uses as an excuse, but he doesn't offer to change those type of things. Instead, he focuses on getting children to work without restrictions. And Representative Wilder's attempt here to conflate this distinction allows him to pass off responsibility to minors and would put them in a position where they're forced to decide if they want to take a break or not, while their employer is likely pressuring them not to. Despite the anecdotes that are put forward here by Representative Wilder of how numerous businesses and all the business owners that he's ever spoken to always allow for breaks, without legal protections in place, it would not take much to coerce a child into deciding against their own interests, as they are convinced by their employers to avoid taking a meal break. This shouldn't even be a shock to people, given that in the United States, adult employees go to work sick all the time. And sometimes they accept more dangerous conditions, including things like not being able to go to the bathroom or having to deal with dangerously high temperatures due to fear based on the threat of unemployment. So, why should we expect this to be any different for teenagers? In fact, it's all the more reason why we need this law not just for teenagers, but for adults as well. And I think it should go without saying that everyone should be entitled to a meal break after working a certain number of hours. Breaks are healthy and food is important for people. However, it's also far more important for children who are still growing and still developing to be able to sit down to a proper meal without having to rush or work during their break. It should be evident from this alone that the goal of this bill is to enable employers like Representative Wilder to exploit the labor of children by defining them as full adults, who are fully capable of decision making and whom he can exploit with minimal repercussions. Also, in this conversation about labor, I do need to point out that Representative Wilder's language sounds dangerously close to someone who is arguing about lowering the age of consent, even if that is not the topic or the intention here. And speaking of age, Representative Wilder also seems unaware of exactly which age groups this particular bill, and thus the repeal of the previous law, would actually affect.
Does this bill only deal with 16 and 17-year-olds?
To my knowledge,
Okay. At what age can you get a work permit in Louisiana?
I believe you can get a work permit at 14, but the restrictions on 14 and 15-year-old employment is so egregious. If you try to navigate it, you're going to be, it's almost like, oh, you hired a 15-year-old, I'm going to come get you because you can't navigate 2-hour shifts. I think it's 3 hours on a weekend, and I tried that once, and the parents are like, I got to drive my kid 30 minutes to work. Why would I drive 30 home and pay the gas money of their wage?
So 14 and 15-year-olds would not hit that 5.5-hour threshold, is what you're saying?
They can't by law, and
Okay.
quite frankly, due to the complication of the laws, no one I know hires 14 and 15-year-olds.
I mean, I worked as a 14-year-old and a 15-year-old in the state of Louisiana, and I know people in my family that do as well. So
Yeah, I just like to know what I know.
Yeah, so I do know. So
If we look at information provided by the Louisiana Workforce Commission, it's worth noting that 14 and 15-year-olds can in fact work 8-hour shifts during the summer months when school is not in session. This means that the repeal of this law would deny meal breaks not just to 16 and 17-year-olds, which would be vile enough, but may in fact put some children as young as 14 years old in the position where they have to negotiate breaks for meals with their employer. So this brings us to the next question. In Representative Wilder's opinion, what should a child, even one as young as 14 years of age, do when they feel exploited by their employer? Well, according to him,
Problem. But my point is, there's a free market. If an individual's working in an establishment that treats them bad in any way, they can resign. So if a team member says, if an employer says, you're not going to get a break because the state doesn't make me, that team member can offer a resignation and leave whatever restaurant in that strip center or whatever GameStop or pick a business, retail restaurant, whatever. They go right next door to the now hiring sign and they apply.
Okay.
Yes, the free market solution of just leave your only place of employment to go get exploited by the business next door. The solution isn't to hold businesses accountable, but to allow the free market to decide with the assumption that all employers would just be benevolent and act in good faith, and that if they don't, people can just leave. As if the populations who are most likely to send their young children to work are not the most vulnerable and most likely populations to be exploited. Without this law on the books, I think it should be evident why this wouldn't work, as the circumstances are unlikely to be very different between places of employment, especially when all of them have the financial incentive to push children into not taking a break or flat out firing them for desiring to do so. Further, the real answer here should be that people should form a union, should start looking in the direction of having worker cooperatives as a bare minimum here. Now, something like that is a lot less likely to happen from a worker who is under the age of 18 and doesn't know all of their rights. And I have to assume that Representative Wilder knows this. And despite all of that, Representative Wilder and his colleagues here blame children by claiming it's actually them who desire to not take breaks.
Even if the minor doesn't want the break, wants to continue working, because don't they lose money when they are forced to take a break?
They have to be off the clock. One
Correct.
of the issues one of my locations ran into was they were just letting the minors go eat. And they said, don't worry about clocking out. We don't need you to, we'll pay you.
Yeah, I have a grandson that's 16. He's been working for a year, and he declines and constantly about this continuous break, and but he's not allowed to.
Team members will have more employment opportunities in the 16 and 17-year-old category for those who want to work. That's what this is about. Not many people want to work right now. And the ones that do, we're just telling them to sit down and forfeit a big chunk of their paycheck when they don't want to.
In a lot of this discussion, Representative Wilder and his colleagues seem to indicate that children are in fact the ones who wish they could work through their breaks. However, in none of these cases have they ever presented an actual child who has come forward and admitted to wanting this. And in fact, this is a really strange argument to me, because I also cannot imagine a child wanting to work for 6 to 8 hours in a row without taking a break, especially to have a small meal. It seems far more likely that bosses would coerce children to not take breaks for one reason or another, and to manipulate them using language about whether or not they want to work, and by trying to convince them that they're making more money when they're not. Further, if Representative Wilder is so concerned about the children being paid, then he can pay them. He can make that choice. The law as it's written indicates that the boss can't control the worker's time during the duration of a break. But I highly doubt that anyone's going to stop him from adding an extra half hour of pay onto everyone's shift, since he's so willing to pay for that time. In fact, he should be benevolent and actually just do it instead of doing all of the things he's doing to try to circumvent and change the law. However, the trick here is that he's not looking to pay them more per hour. He's looking to extract more labor time from them. And yes, he's willing to pay for that time, which I guess is better than some circumstances, but it's a distinction that he seems to not fully understand, since he doesn't truly seem to understand what a wage is.
Bottom line, I think a lot of us, myself included, I came here to create jobs and increase wages.
Okay. Last question. So you said at the beginning that this bill is to help the kids.
It's how it helps both. It's wages for minor team members.
Well, it doesn't increase their wages. It just allows them to get paid for the time they would be taking a break.
I would argue a bigger paycheck is an increased wage. We can go with it both ways. Yes, sir.
So apparently, I need to clarify here what a wage actually is. And that's not something I feel like I should have to do for a representative. A wage is a payment for a specified amount of money over a specified amount of time. For example, the United States' federal minimum wage is $7.25 per hour. One does not get an increased wage by working more hours, even if their paycheck is in fact a little higher, because they worked more hours. That is because their hourly rate or hourly wage does not change. So Representative Wild here, getting to exploit another 20 to 30 minutes of a child's labor, will not in fact increase their wage at all. But this conflation makes it seem like the removal of this law will result in a wage increase, when in fact it does not. And quite to the contrary, it'll likely make wages overall go down, as this will likely remove a barrier to hiring children, thus making it more likely that employers will seek out child employees who they can pay less instead of paying adults a living wage. After all, that's the point of expanding the labor pool to include children. You can pay them less, and they have less knowledge of how the law works, and so you can get away with more. That said, let's take a look at another thing that Representative Wilder seems to not fully understand, namely the federal law.
We offer the same break period to all employees. We just don't force them if they don't want to. They can take 10 minutes, they can take 20, they can take up to 30, 35, and before it becomes, okay, get back on the clock. But we don't have that issue. Most of the team members we hire have initiative. Otherwise, they don't show up to want to work. When they show up to want to work, they it's a 5-hour, 6-hour shift after school or on a weekend, and they say, you know what, I want my wage. I'd like to go sit down for 10 minutes if I want to and grab a bite to eat. But I'd like to clock back on and start working when I'm done instead of sitting there idle for 20 more minutes or whatnot.
In these clips, Representative Wilder seemingly admits that his employees clock out for 10-minute breaks and then clock back in, something that he wants his teenage employees to be able to do as well. The trouble is that federal labor law mandates that breaks under 20 minutes must be paid. It says here that federal law does not require lunch or coffee breaks. However, when employers do offer short breaks, usually lasting about 5 to 20 minutes, federal law considers the breaks as compensable work hours that would be included in the sum of hours worked during the work week and considered in determining if overtime was worked. Meaning he has to pay for all that. If this is in fact accurate, and he is fully admitting what he seems to be admitting in the middle of these sessions, it is evident that Representative Wilder should not be trusted in this capacity to interpret, understand, and especially rewrite the laws, given that he can't seem to actually follow the federal laws in his own business. His employees should in fact not be clocking out for 10-minute breaks. And that isn't even addressing the disingenuous assertions he makes time and time again throughout these hearings that people need to be idle or sitting for 30 minutes. When I read you the law earlier in this video, there is a section that determines that 20 minutes is a perfectly acceptable amount of time for these lunch breaks. So no, people are not sitting idle for 30 minutes in a row. Now, as you can see, Representative Wilder is either flat out lying and being manipulative, or he's ignorant of the law he's attempting to repeal. I'm not sure which, but the fact remains that he read this law out loud during at least one of these sessions, and somehow is still getting this wrong. Make no mistake that this effort on his end is explicitly designed to help his business, and businesses like his, to hire younger children with less barriers and paperwork, and all the while pretending he is doing them a favor while he's exploiting them. Hopefully, I've been able to demonstrate to you today some of the ways that elected officials like him twist the narrative in order to suit their own agendas and self-interests. And if there's any doubt in the way that I cut these clips, or if you want to verify for yourself, I encourage you to seek these clips out as they're available on the Louisiana State Legislature's website. The fact remains that it has always been labor movements, unions, and left leaning groups, including anarchists and communists, who have fought for these types of protections to be put in place and to make sure that children were less likely to be exploited under capitalism. It's always in the benefit of employers to remove guarantees and protections for employees and to hire more vulnerable and exploitable populations. It will always benefit employers and not workers to remove paper trails and leave things up to the whims of a boss who would prefer to function like a feudal lord over his employees without interference by government or union agencies. The less knowledgeable their employees are, the younger that they are, the less likely they are to defend themselves and protect themselves when these types of violations rise up in the workplace. They must form unions, demand better pay, or change their circumstances of employment in order to actually achieve better outcomes. And at this moment in time, I do need to remind you all that there are people doing this, what Representative Wilder has done, in almost every single state legislature in the United States. And honestly, it needs to be stopped. So with that said, if you've learned something here today, you can support the channel by liking the video, subscribing, or doing any of the YouTube algorithm things. You can also consider checking out the links in the description down below to my Discord, where we have great conversations, or to the Patreon, in which you can financially support the channel. But please only do so if you are in a financial place to do so. With all of that out of the way, my name is Anarchist Tara, and I thank you so much for watching.